rule, no, that they did not. So out of that, our first judge alone trial outside of SIP happened in a murder trial of a guy named Malik Cox, where some Andrika Stubbs was shot outside a club, or outside on the opposite side of Fortis. And that case went to the Privy Council on appeal in December of 2022, and the conviction was upheld. It was the first trial outside of the SIP court that we used that. So we've been able to use it more often now and get there. So you lose a case at the magistrate court, you can appeal to the Supreme Court, and a judge at the Supreme Court will hear your appeal. You lose a case at the Supreme Court, you go to the Court of Appeal. We have a visiting Court of Appeal. So they come in 3 or 4 times a year and they sit for about 2-3 weeks and they hear all appeals, whether it's civil or criminal, and they give their decisions. And if you lose there, the final Court of Appeal is the Judicial Committee of the Privy Council, if you call it Privy Council, which sits in the UK, of the UK Lords. One of the, we had a very important decision released from the Court of Appeal on the 29th of February, and it was a case that was dear to my heart, passionate about it. We had a few cases where American tourists were coming into the country with firearms and/or ammunition. And when they were arrested, the judges were giving them a fine. And the law says any firearm offense, it's a mandatory minimum of 12 years imprisonment and an unlimited fine. But then it gave them, because of the constitutionality of that, the Parliament cannot interfere with the fetter of the judge, the discretion of the judge, sorry. So they put what they call an exceptional circumstances clause, that if the court finds there are exceptional circumstances, they can go below the minimum. And it was that the judges found that were exceptional circumstances, and they would give these people a fine, $5,600, $3,500, and let them go. And I argued to the judges that you cannot do that. The law says 12 years and a fine. So the person must go to jail. And I was told that I was wrong. I was wrong. I was happy the Court of Appeal said you were right, you were right. So now everybody who gets a firearm offense will go to prison and can get a fine. Much prison you take depends on the circumstances of the case. So firearms is an offense that the magistrate has no jurisdiction over. It goes straight to the Supreme Court. Magistrate cannot even grant bail where you charge with a firearm offense. And we know that that came about as a result of the explosion of firearm offenses. When I left here in 2009 March, there were an average of, say, 3 murders per year. I swear not, 2019 March. And in one summer of 2022, there were 31 murders in one 30-day period, all gun related. And there are about 8 or so for the year so far. So we're looking at 40 something if we maintain that average. And then we had one stabbing, but all the gun offenses. And like the Court of Appeal said, Parliament intended for a deterrent to send people to prison. So when you don't give people prison sentences, the deterrent, the dominant intention of Parliament is not being met. Let's touch a little on search warrants. As a JP, the police is going to come and bother you and call you at all hours of the night that they want a search warrant signed, we got something to have a GPU, whatever. Like I said, having been a police officer, I love the police, and I would like you to bend backwards to help the police, but you have to do it within reason. You have to do it within the law. Don't make them bulldoze you. Don't make them push it in front of you and say, sign that. We got to go. No. They must swear on information, on oath, to the information that they are providing you. You, as a JP, must be satisfied that that information that they're providing you gives you, convinces you that you should sign and approve that search warrant. You have to say to yourself, are you giving me a 619? Or is the information that you're providing me cogent that can lead me to give me? You're not looking for evidence. You're not asking for hard evidence, but you're asking for logical reasoning that Clement is suspected. He was seen at the place. We suspect Clement. We have intelligence. We have information that Clement is the person who committed the offense, and that what we are looking for is at his residence. And we would like a search warrant to go there and search for it. So you sign the warrant and you go. What if the warrant is defective? What if the warrant is not, there are procedural mistakes on the warrant? Does it invalidate the search? Does it make the search unlawful? The court says, yeah, can make the search unlawful, but the evidence is still admissible in the trial. Go sue somebody, sue the government, and say that the JP acting on behalf of the state was wrong to have given the search warrant because there was not sufficient evidence before him or her for him or her to have given the warrant. This is not to chill you as to whether you sign a warrant or not. Like I said, just make sure that it's clear in your head the reason why you signed this warrant and that it's there. But as far as the law is concerned, it not matters even if you stole the evidence, it is still admissible in court. So they would go and they would sue for trespass to their property and those types of things. But the warrant would still be good. And we have a case out of Jamaica that was similar to that, called Williams and another. AG of Jamaica and Williams. And customs case, and they got the warrant and they went there, and the police recovered some stuff that was not listed in the warrant. And for your information, they will tell you that they're going to search for computers and electronic products and stuff like that. They're going to meet drugs, though not listed in the warrant, they still can take it. If they meet firearms, though not listed in the warrant, they can still take it, and it is lawful. When they go into the house to search, anything that they meet which they suspect is to be part of a crime, they have the right to seize, and it can become evidence. AG and Cecil Toussaint in St. Lucia, the warrant was obtained to go search the house of one Ras, as in short for Rasta, of Babune or something like that. That community is as big as Turks and Caicos, as Providenciales, right? So you can imagine how many Rastas were in that community. But all the warrant said was Ras of Babune. And they went and they searched Ras, and they got what they wanted. They got drugs, they got a whole bunch of cash, they got a whole bunch of stuff. And the court, the judge, when he challenged it, the judge agreed with Ras, with Cecil Toussaint, that his name was not Ras, and the police should have Ras. The government, the Attorney General, took it to the Court of Appeal, and the Court of Appeal said to the judge, come on, please, you cannot throw the case out for that. They had the correct address. So you have the correct address. So I tell you that to say that a police officer may come to you and he may not have the name of the occupant of the address. Police officer may get information that you see that house there. Last night I see some guys parked up there and offloading what look like drugs, like what look like guns, whatever. And they have to move with speed because by the next hour it's gone. They do not know the name of the occupants of the house. So they might come to you with just an address. That is okay. That is okay. they give you a proper description of the property and the address, that is okay. You can go ahead and sign the warrant for that. Okay. We look at appointments of the JP. Sorry, go ahead. Uh-huh. Yes. Oh, so this, okay, let me help you there. When they went to court, the judge, we call that the judge at first instance, the first judge who heard the matter, he threw it out. The Attorney General appealed his decision, and the Court of Appeal overturned his decision. And the Court of Appeal says they didn't have to know his name. They had the correct address. They were right. So the law now is not based on what the judge said, that you had to have his name, but based on what the Court of Appeal, the higher court said, the address was okay. Yes. Right. Yeah. If they come to you and they tell you that there is this building we want to search, and they give you a description of the building, a number, a house, a street, or whatever, they give a description of the building. It is a building that is between where Mr. John live and Mr. James live on Front Street, and it is a two-story building with painted in pink or something like that. That gives you a clear description. You don't have time to physically check it out, but you are going on the information. They're swearing on oath. They can be charged for perjury if they lie, because their information to you is on oath, that I swear that what I'm telling you, that I believe it, or I verily believe it to be true. And if they can be shown that they were trying to bamboozle you and trying to whatever, they can be charged and convicted for perjury. So it is something that you have to rely on their truthfulness. That's what they're telling you. But yes, the building, a description of the building could suffice. Yes, this description of the building, because our house lies on a certain street, it doesn't have a number, because you know, in some of our small islands, they are not numbered buildings per street or so. But you can get some sufficiently proper address. Yes. They fill out a form, an information like, and they should swear to information. That the information that I give to you in writing, because it spells out the reasons for the search, and I make them, they have to put up their hand, swear them, that what is in that information is to my belief and true, that that is what's happening. Yeah. There was a case from Guyana where some lawyers got a loan from the Guyana Central Bank, or some bank in Guyana. But one of the sisters lives in Jamaica, and the bank took them to court to recover the money. She went to a JP in Jamaica to sign the papers for the application of the loan. And she gave the JP, had Guyanese driver's license, and he annotated that and whatever. But when the case went before the Caribbean Court of Justice, she was saying that she never signed. She doesn't know anything about that, to try to say that she doesn't owe the bank. But the court held that it is impossible for the JP to have gotten her Guyanese driver's license. And it's not somebody that he knew. And he only knew, and luckily, he took down her information on the license. So they held her to be responsible, and she was to pay. So some people are justices of the peace, what we call ex officio, by virtue of their position. So like a clerk of the magistrate's court, probably a clerk of the Supreme Court, becomes a justice of the peace, just because of their position. The commissioner of police becomes a justice of the peace. And when you're going to, by virtue of your office, the application is made to the governor. And when it's not by virtue of the peace, it's made to the registrar. I think the registrar of the magistrates court is the registrar that they're referring to, rather than the registrar of the Supreme Court. You must be a resident of the islands. You must be of good character. You must be able to understand your duties and your powers. You must be sufficiently proficient in speaking, reading, and writing English. You must live and work in an area or community where there is a need for a JP. And you must not be disqualified. All right. Which one? Resident of the islands. Good? All right. Your powers. You have the same powers as a magistrate. And I can't stop there, so don't go and send people to jail. It gives you the powers of the magistrate that you have. You can receive complaints. When they say receive complaints, those are the written complaints that the police would have done, signed. You can sign charges. So when the police sign those charges against an individual, it has to be, we call it JP'd. So it has to be JP'd, and they bring it to you. Some of you may have seen it, where you put your stamp on it and you sign off on it. And then they take it, they lodge it with the magistrate's court, they get a date for the person. Issue warrants for apprehension. A warrant of apprehension is what we refer to a warrant in the first instance. A person commits an offense and it was not in the presence and review of the police officer, and they want to get the person arrested. Every day the police just go look for him and pick him up. But people don't challenge that like that. But the police cannot just go look for him and pick him up, you know. If somebody come and report that Clement slapped me down the street, they go pick him up and they tell him, get in the vehicle, and he'll get we just throw inside. They must come and swear to you on oath for you to sign a warrant in the first instance, which is a warrant of apprehension, to go arrest a person. All right? So that's what a warrant of apprehension is. And a safe commitment for safe custody of those charged. So, warrant, put the person in safe custody until the person is brought before a magistrate. Issue search warrants, we went over that. To issue summonses. So the police going about, they're looking for witnesses or defendants and they want a summons. They can have, a JP can sign that and put their stamp on that. And that is an order of the court. If they don't come, they can be, a bench warrant can be issued by the magistrate for the failure to attend because they were served with a valid summons to appear before the court. And again, to administer oaths. So a person is doing, they want to swear to an affidavit, they want to do some oath of office or something like that, they can go to a GP and you can do that for them. You do not have the powers to grant bail. So that doesn't come up to you. Some countries, JPs go to the station and grant bail. I'm not from Trinidad, but Trinidad has everything across the spectrum of law and crime I find in Trinidad. So you'll find that a person is arrested on an offense. A police officer can grant bail in certain instances here in Turks and Caicos Islands. It's called station bail. But like in Trinidad, a JP can go and grant the bail equivalent of what a magistrate can grant. And then the next time that they go to court, that bail can either be ratified or modified by the magistrate. But here, you don't have the option of granting bail. Probably something that they can look at in the future to widen the powers. You don't have the power to direct the police or any other law enforcement agencies. And when I see that there, let me remember, a customs officer can come to you, for a warrant. An immigration officer can come to you for a warrant to go search somewhere because they are law enforcement officers. Member of the Integrity Commission can come to you for a warrant to go search. Member of Fisheries can come to you for a warrant to go search. But what you have to be careful of is that they have that power to go search. Do they have the power to go search? If they don't have the power to go search, you can grant them the warrant. A fisheries officer one time picked up he had some people and he brought them, came to the office, he some people for illegal immigration. And I tell him, take me to the legislation, we can do that. Takes me to a part of the legislation that says that they have the powers of police, but he misses the part that says in enforcing stuff under that ordinance. So his duties under that ordinance, he has the powers of police. So all his duties under that ordinance, if he has a duty to search or whatever, he can come for a search warrant. But he cannot come for a search warrant to go and search. A fisheries officer can't come for a search warrant to go and tell you that Clement have handled stolen goods or he have drugs at his home and I want to go search it. No. No, he can't do that. The police can. Customs officer can come and tell you that I believe Clement has goods that was smuggled into the country at his home. Yes, he can get a warrant. You can give him a warrant to go search for those smuggled goods. You can give him a warrant to go look for anything that has to do with a customs offense. So it becomes ticklish when it's outside the police. You probably have to go read up that particular ordinance to see whether that officer has that duty. Yes, ma'am. Yeah. I hope that everybody have an ID card. I'm hoping that the fisheries people have identification. I'm hoping that all law enforcement persons should have their specific identification card. Probably something I need to find out too, and let them know that they need to have that. So they come to you. The information upon which they're going to swear, take the oath, must set out the legislation under which they're operating. So you can just do a quick look of the legislation, go to the Attorney General's website, look at the revised laws, pull up the legislation, and look at that section. And say that section does not apply to you. And no, sir, that section does not apply to you. You can call it the Attorney General's office and ask for quick advice. You can call our office and ask, hey, there is this guy here from this department looking for a search warrant. I want to know whether I'm authorized to give you. This is a section he's coming under. Do a quick look and say, nah, don't do it. Tell him to go to the police so the police can apply for the warrant on their behalf. But he cannot independently apply for that warrant. Yes. I'm not going to lie to you. The regiment isn't new to me. And the way I understand regiments and forces like that is for external security, and they're not supposed to operate as a domestic force. So I want to jump on the bandwagon unless I'm proven otherwise and say that they have no right to go search. They can assist the police in a search, but they cannot come to you for a thing. But when I go back, I'm going to research and make sure I'm right, and I'll send the response to Mr. Emmanuel so he can issue you all. But I for now, I'll fall on my sword and say no, they cannot, because that's what it is for, external defense of the country, and the governor can mobilize them to assist the police in cases of emergency that she sees and deems fit. Okay, some basic law processes. A person can be brought to the court in 3 different ways. They can go out there and can see an offense, and they can arrest a person and bring him to the court. There can be a slight offense like a traffic offense, a simple slap in the face that causes no injury, and they can issue a summons and they can tell you you need to show up at court on a certain date. Or by a warrant in the first instance, which we described earlier as a warrant of apprehension, where they come to you and they tell you this person committed an offense and I now need the warrant. So for instance, like when we had a case when I was here previously where a guy was arrested and he escaped from custody. About 5 years later, another guy called the police and said that his house was burglarized. And police officer went to the scene. And police officer said, but you're the one that ran away from me 5 years ago. And he arrested him and charged him for escaping from custody. And the Court of Appeal let him go, you know. Anybody have a slight idea why? Just past 6 months. So it was a summary offense. Escaping custody was a summary offense. You had to have arrested and charged him within 6 months. So what should the police have done? As soon as he escaped, get a warrant in the first instance and put it on the shelf. So the charges would have been implemented within the time frame. So now, could take 1,000,000 years later, now you're caught, we can execute. So that is how he was able to escape that. So where's a summary matter? The magistrate court has jurisdiction and can proceed to hear and determine the matter. So 90% of the cases happen at the magistrate's court. 100% of criminal trials or criminal process starts at the magistrate's court. Every time you charge somebody for a criminal offense, it has to start and go through the magistrate's court. So they can only do with matters that are summary, or those are what I referred to earlier as triable either way, where the legislation allows them to be tried either way. Where it's an indictable matter, a serious matter, the magistrate court commits it to the Supreme Court for trial, for sufficiency hearing, where that the Supreme Court, a judge, will determine whether there is sufficient evidence to go forward before a judge and jury. Yes, ma'am. In nature, it is not a serious matter. It is not. And again, we used to go by the punishment. If it was more than 6 months, less than 6 months, it's a summary matter. But now, as I explained earlier, statute has changed that. So offenses which are not that serious, that serious, there is no serious injury to persons or property, and can be dealt with at the magistrate level. But where you have cases where there is serious injury, serious loss of property, value, etc., then you want those matters to be indictable. So let us look at murder. That cannot go down there. Rape, that cannot go down there. Firearm offenses, the legislature has said, no, that is strictly indictable. Manslaughter, second? Arson, those kinds of where you have properties, value of properties going, they cannot stay down at the magistrate's court. Theft is a case that can go either way, because if you steal 2 mangoes, we're not going to get a jury for you. We'll deal with that at the magistrate's court. But if you steal $70,000, we got to get 7 people to decide whether you should pay for that or not. All right? So, in conclusion, the law is wide-ranging. The law has developed over thousands of years, and it continues to develop. Why? Because as human beings, we continue to get innovative ways of doing wrong to other people. We come up with a whole new regime of doing stuff to hurt other people. And then as governments, they find that, wow, we can't find anything to charge these people with. Should they really get away with this? And either they find from some other jurisdiction, there is a law that they combating that with, or we develop one on our own and we deal with it. And we create a law to deal with offenses and that type of thing. In most, if not all, Caribbean countries, there's something called a Limitation Act ordinance, that after a certain period of time, you cannot bring matters before the court. So for summary matters, the person must be charged and brought before the court. Not necessarily brought before the court, but they must be charged within 6 months. If you don't charge a person within 6 months, they're going to get away. So you charge them, they can run away, but it's still there. When they come back, we'll still deal with you before the magistrate's court. Indictable matters, you can die, resurrect, and come back. You don't charge it, we will charge you then. There is no time limit for indictable matters. Customs, for summary matters, customs in some countries are given as much as 6 years. I think for here it's 3 years. Why? When you commit a customs offense, you can go into negotiations with the collector of customs to do what you call an administrative hearing, where they will fine you and you just pay that and you have no conviction. Imagine if that was 6 months, you will just run out the clock. You just keep negotiating and negotiating and negotiating. And when the 6 months pass, you just tell the collector of customs to hell with you. And they can't charge you again. So I guess somebody got bit by that one time. So legislators all over the Commonwealth of Caribbean, over the world, realize we need to give customs some years. So if you think you're going to get away, and then customs officer will just say, okay, no problem, I'll charge you. And you will get a conviction and you'll go before the court. And then most people don't want a conviction. So what they do is they run now, and the same settlement that they were trying to avoid, they pay. Some customs collectors, they say, okay, I'll feel for you, I'll take the payment. Or they say, no, you were bad, you were disrespectful, so face your peers. Ladies and gentlemen, if I can be of further assistance to you, please reach out. I'm sorry I did not put my number there, but I can give you my cell phone number. You can take it if you want. You can call 246-6003. We have an office number, but we are being 246-6003. We have an office number 338-4279, but we are being evicted and all telephones will have to be, they have to set back all of that. It's going to take a while. So we move in at the end of the month. Our office is on the second floor of the bank. The governor likes it, so she tells us to keep moving. So we are moving to some offices which sits at top. I think NIB was there before, right on top of the Grace Bay Police Station. Yeah, so that's where we're going to be, on top of the Grace Bay Police Station, effective, well, not 1 April, because we're going to be moving boxes and stuff like that. So. Say again, please. According to the Constitution, I plead the fifth. Thank you, gentlemen and ladies.
Thank you, Mr. Joseph.
Yes.
We have one question from you for the chat.
Yes.
It would be helpful to answer it before we go. I'll read it.
Okay, yes.
This specific form that must be presented or filled in by the police officers when a warrant is to be signed.
Yes, the police officers have an information or sheet that they have called an information on oath, something like that. And it puts there the offense that they suspect and the section of law under which that they are going to or that they want the warrant issued. So the police officers have it. And like I say, the customs may not have one, but they can borrow the police own and put the customs and the immigration are very smart. They borrow what the police have and they put their own logo on top of it and they use it. And the police can come to you for a warrant on behalf of any of law enforcement agencies. They can come. But the police just have to know that what he's swearing to is the truth, the whole truth, and nothing but the truth.
Just one question, if I may.
Yes.
And this may be a bit mischievous, but I know that there are certain persons for religious reasons do not take an oath.
Yes.
Or do not give an oath. Would the same person who, if he is to give an oath, would not give an oath, if someone comes to him that is required to take an oath, is he able to accept that? Or should he, in all those cases, do an affirmation?
That question was answered in a court case having to do with a juror. He says, so help I Jah. And the judge refused to take his swearing. And the Court of Appeal held whatever binds his conscience is what is required. So he doesn't have to be a Christian and say, so help me God. He doesn't have to say, I affirm. He can say, whatever binds his conscience is what is required when it comes to an oath. Yes, it is. Because I can come and say, help me, Satan. I'm an atheist, and that's where I go. But that's my conviction, right? That's my conscience. It's like in the army when they try to send you to war and they try to say you have conscientious objector. You do not believe in war. And they will go through this whole thing to say how long since that come about? Is it only because we declare war?
We have two more questions from Dr. Herbert Fulton. Sir, what about civil citations for minor offenses, such as driving without a license or with faulty headlights? Whenever is a civil citation given?
According to legislation, so the traffic ordinance would tell you they have these what they call fixed penalties, where you can get a ticket for certain traffic offenses. And they'll give it to you and they'll tell you that you need to pay this ticket by the 10th of April. And if you don't pay it by the 10th of April, you need to show up to court on a certain date. They'll give you a date. So that's how these fixed penalties, the civil citations are given. The the planning department can come and give you a fixed ticket, They can see you building or doing rehabilitation and you do not have approval. You do not have a permit to do that. And they come and they're going to give you a ticket and they're going to tell you break it down. But they're going to tell you to stop. And we have a lot of those. And you ain't going to stop. You don't buy how much cement and sand and stone and block. And you ain't going to stop me. And I already have 2 people for those apartments, so not you. And they take you to the court. Planning department can take you to the court. And they get what you call a fiat from the DPP. They can prosecute it themselves, or we could prosecute it on their behalf. And the court has wide-ranging powers. Court can order you to break it down. The court can, and when they give the order to break it down, they can put a penalty. For every day you don't break it down, you're going to pay $100 fine. So those are some of the things that the fixed penalties it's looking at. And the purpose of fixed penalties is to unclog the court system, to make it more efficient, and hoping that as trespassers of the law, that we will choose to resolve our issues in a more amicable, easier way than go for litigation. I hope that answered your question. Okay. Oh, all right, thank you. So over to Antonio. Introduce.
Right, so good afternoon, Mr. Joseph. Thank you very much. And we now hand over to Mr. Gardiner for his presentation. Regrettably, Mr. Joseph needs to be excused. He has a court appointment, so we thank him very much, and we'd ask you to give him a round of applause at this time.
Forgot to introduce Ms. Richardson. She's the new prosecutor. So you can bug her unnecessary.
Thank you for that. Okay, good afternoon, everyone. Thank you, Ms. Now, I have been asked to give a brief conversation on the liquor licensing ordinance and the workings of the liquor licensing ordinance. We would all be aware that the liquor licensing ordinance is a 1975 legislation with a number of amendments over the years that has sought to bring it up to date, certainly as respects licensing hours. And we'd have to also recall that when this legislation was initially done, there were 3 liquor licensing districts. Those would have been Grand Turk, Salt Key, and South Caicos. In fact, it would have been the Caicos Islands district. You would recall also that those are the 3 districts that were responsible for the 3 parishes that we have. St. Thomas Parish is Grand Turk, St. John's Parish is Salt Key, and St. George's Parish is South Caicos and the Caicos Islands. All of everything west of the buoy, St. George. However, as time went on, because it became more activity began to happen in Provo initially, then Provo became its own district. And then more activity happened in North Caicos and Middle Caicos, and now North and Middle Caicos are their own separate districts as well. And so there are districts that covers the entirety of the islands and there is a presiding justice for the purposes of the liquor licensing ordinance in each of those districts, and the membership of the liquor licensing authority for those islands, all of the justices of the peace will reside in that area. And so, for example, if you live on Provo, you are a member of the liquor licensing authority for the Providenciales Island District. If you live in Salt Key, you are a member of that liquor licensing authority. One of the difficulties we have is that certainly as the presiding justice of Providenciales, we have sometimes when we have liquor licensing meeting, no one shows up. And sometimes we have to postpone it for another week in the hopes that we can get people to show up. And sometimes we barely get a quorum. And so we have been working on that in the hopes that we can get that redressed. Now, the liquor licensing ordinance says that anybody, if you're above a certain age, can drink alcohol. However, not everybody can sell alcohol. So you need to have a liquor license in order to sell any alcoholic beverages. And not only would the person who applies for the license, not only is that person licensed to have an alcohol selling establishment, but the premises from which he sells alcohol must also be licensed as a property that you are allowed to sell alcohol from. And in the old days, persons would never have given a license to operate a bar or a restaurant selling alcohol or an off license in premises in close proximity to a church or school, for example. Those things, because the people who attend these meetings don't really care about those kinds of issues. You find that the mindset of the licensing authorities over the years have changed, and persons are less inclined to take those matters into consideration when granting these licenses. And so you have these things popping up everywhere. Now, the liquor licensing ordinance provides a quorum for the number of persons that makes up that is needed to have a meeting. And these are very small numbers. So, for example, section 4.5, subsection 4 of the liquor licensing ordinance says that no business shall be conducted by an authority unless there's a quorum at which shall be the chairman and 2 justices, except in the case of Saul Key, the chairman and 1 justice. And I can tell you, certainly on Provo, sometimes we can't get 2. And sometimes in fact, in December, when we had our annual licensing session, we had to postpone it for a week in order, because the legislation says if you try to have a meeting and you can't get a quorum, after a certain period of time, you must adjourn the meeting to another date. Yes, ma'am. The justices are notified by email contact that would come from the clerk, from someone in the magistrate's court. Very well. I will take that up.
Please put me on that.
I will take that up, and we'll try and I'll ensure that it's widely circulated.
Can the ordinance be shared?
Yes, you can find the ordinance at the webpage for the Attorney General's chambers, and it's there. It's called the Liquor Licensing Ordinance, and it's you look for ordinance 19.11, and you will find the Liquor Licensing Ordinance there. Yes, sir. Yes, ma'am. Well, what we have here, for example, in South Caicos and in the islands where you have a district commissioner, the district commissioner is the secretary. In the islands of Provo and Grand Turk, where you have no district commissioners, there's someone in the court that has been appointed as secretary. So in our case of Providenciales, the secretary is Ms. Claire, and she would generally send out the notices. I'll have to find out how deep and wide that circulation is, but I know that we have been having major struggles finding a quorum. In fact, our meeting was meant to be on Tuesday, gone this week, for reasons including accommodation. We couldn't put it on, and we are gonna advise when that meeting is gonna be. Now, the legislation provides that there are 4 meetings a year. There's the annual licensing session, which must be held the first, not later than the 2nd Tuesday in December. And then there's a licensing session in March, June, and September every year. Quarterly on the 2nd Tuesday of the month. Okay? And in certain circumstances, those can be postponed. Oh, thank you. Grateful. I'm an old man, so sometimes the glasses work, sometimes they don't. And certainly they never fail me. I have to put them on in order to hear. Okay, now the licensing authority has the permission, the powers to grant licenses, to revoke licenses, to suspend licenses, and to do a number of other things. Sorry, not revoke. And I said revoke, but not revoke. To revoke a license, the authority may make an application to a magistrate or a member of the public may make an application to a magistrate, and a magistrate can revoke. If the authority makes a decision that any person is aggrieved of, they have a right to appeal to a magistrate, and that magistrate or the magistrate can overrule the decision of the authority to grant or not grant a license, or to add or restrict, or to add restrictions as the case may be. Well, I will come to this shortly, but maybe I should look at it now. Because the legislation says that in considering or using your discretion whether or not to grant a license, you must take certain things into account. And those are contained in section 7, subsection 3 of the legislation. One is the age and character of the person who's applying. Then you have to consider the suitability of the premises, having regard to the type of license for which the person is applying. And so, for example, like I spoke to earlier, if it is in close proximity to a school, is it suitable to house a bar, for example? Or if it is in close proximity to a church? Your values may not be what my values are, and whereas I may not have a difficulty with that because I don't see anything wrong with it, you may have a difficulty with it, and because you see something wrong with it. And that is why ordinary members of the public are appointed to these positions to be on it, to balance the values to balance the equation as far as different people come with their different value structure that they bring. You must also consider whether the locality in which the premises are situated you must consider the locality in which the premises are situated and the effect upon the occupants of other premises in the locality and upon the general public of having in that situation licensed premises of the type or kind that is already there. And so, for example, if there are 5 bars in Bottle Creek, for example, when you consider the population that is there, is 5 bars enough? Or should you consider, you know what, we think that that part of the town is well saturated and we are not prepared to issue any more for that part of the town. We're not prepared to issue any more bar license. However, there aren't enough restaurants. You may want a restaurant license. Why don't you consider applying for that? And so these are some of the things that you would have to take into account. Another thing you take into account is the question as to whether or not the needs of the public are already equally catered to. And then, but one key factor that we in the Providenciales district use is because subsection 3 says that in exercising its discretion under this section, a licensing authority shall take into account, in addition to any other matter, these matters that I mentioned. And one of the other matters that we generally take into account is what is the immigration status of the individual. And so, for example, I'm not sure what happens in the other districts, but in Providenciales, a person on a work permit, for example, will not get a liquor license. Indeed, we had a situation where at our quarterly session in September last year, we refused one for that very reason. One of the things that we also need to consider is the persons who are involved in assisting us to make decisions. And so when you make your application for a liquor license, you send a copy to the presiding justice, you send a copy to the commissioner of police or the senior police officer in the district, the chief environmental health officer or the senior environmental health officer in the district, the director of planning or the senior planning officer in that district, and the chief fire officer. And the chief fire officer and the director of planning, these were added in 2018. So before 2018, it was literally just the chief of police, the commissioner of police. Yes, not less than 14 days before the meeting is scheduled to be held, they are required to be published in the Gazette and in a conspicuous place where a member of the public may view them. Now, that is what we use for our description and approval. And so we just leave it at the courthouse. Because what the law says is that for Grand Turk, it's outside of the courthouse in Grand Turk. For Salt Cay, that's outside of the district commissioner's office. For the other districts, for Providenciales, it's outside the district commissioner's office. And for the other districts, it's outside the district commissioner's office. Save that in Provo, there is no district commissioner. And so we have just decided to just leave it at the courthouse. But it is also published in the Gazette not less than 14 days before the meeting is scheduled to be held. Now, once these applications at the meeting, the presiding justice would call off the application and say what the person is applying for, and then there is a discussion on a particular application, and we would generally hear from what the police have to say. They would have concerns about the area or the person, and they may decide, and their recommendation may be that we do not grant. The fire department may say, well, we've done our inspections and there are not sufficient fire extinguishers, or the stove is too close to combustible material. The planning department may say, well, this place is zoned residential and not mixed use, and so therefore this may fall foul of the planning legislation. The environmental health officer may say, well, there are sufficient toilet facilities, or there isn't, because if you're having a restaurant, you must have a place, a sink to thaw meat and a sink to keep meat that has not yet been thawed. There's a place that you're required to keep your washing up, where you wash dishes and where you rinse them off, and then a place separate where you wash your hands. So under the environmental health law, there ought to be in every kitchen not less than 4 sinks. Now, I'm sure that is not always adhered to, but if the environmental health department comes to our meeting and says that from our standpoint, we don't have a difficulty, then we don't go behind what they say and say, well, I don't think that this place has all of those kinds of sinks. The place isn't big enough for 2 sinks to begin with. Another problem that we have been having is when someone applies for a license, and especially when it is an occasional license. That's a good thing. Let me mention that. Apart from what the authority can do, grant and renew licenses generally, the presiding justice has certain powers, like the power to grant an occasional license. So if a guy wants to have a party or on the beach and he's selling alcohol, a one-off party, he may apply for a liquor license or a music and dancing license. He's doing a concert at the National Stadium. He needs to have a music and dancing license, occasional, and an occasional license to sell alcohol. But I need to know, I can't just give you a license to go to the National Stadium and sell alcohol. I need something from the director of sport saying that you have authority to occupy this place for a certain period of time. And so otherwise, someone can come to me and say to me, well, I'm having a party at St. Monica's Anglican Church and I want a license, and then you don't bring me a lease saying that or something saying you have anything there, and I give you a liquor license to go on at the church or go to property and have and thing. That's not, you can't do that. And so one of the things that we insist on is to have the consent of the owner of the property before we give those things. Now, in certain cases, dealing with certain government departments, especially, it becomes difficult, and we acknowledge that. The other thing that people do is that a lot of times people come the very last minute to make an application, whereas the legislation says that an application for an occasional license must be not less than 30 days before the event. But when you say to them, they come to you, they have advertised, they have paid $40,000 to their artists in Jamaica or Bahamas or wherever they're coming from. They have bought them, they've brought them in, and the day of the event, the day before the event is on a Saturday, the Friday they want to come and apply for a liquor license. And if you say no, it becomes a problem. But the law says you must come not less than a month before the event. And there's a reason for that. Well, there's a practical reason for that, is that if I say no as a presiding justice, at least you have time to go and appeal to a magistrate who may overturn my decision. But if you come at 4 o'clock on a Friday afternoon and I say no, where do you go?
How can you do your due diligence?
Well, you can't. And the law also says that before I give it, I must make sure that I've given the Commissioner of Police reasonable notice that I intend to do so. Giving the Commissioner of Police an hour's notice that I intend to do so, it is not going to be adequate. One of the things that we ask for now is, if you are doing an occasional license, the police wants to know that, what about security? The fire department wants to know, do you have sufficient fire outing equipment to apparatus to extinguish any fire that these electrical wires may produce? What about, do you have sufficient parking? Planning may say, do you have sufficient parking or sufficient plans for adequate parking that may not interrupt the roadway? They always say yes. And they say, well, they have arranged for this and for that and the other. But when you drive along the place, everybody's parked on the road. But you have to go based on the application that's before you. And then the environmental health wants to know, are there going to be sufficient sanitary apparatus to make sure the place is tidy? And then we also want to know, what are your plans to clean up after you're done? And once we are satisfied with that, we'll go ahead and issue the license. Yes, ma'am. If you're selling alcohol, yes. If you're not selling alcohol, no. Any place where alcohol is being sold, you'll need a license. If I'm having a house party and my friends are coming around and I'm not selling alcohol and I'm playing music, it's not a problem. Well, that is one of the things that we are meant to take into account is what the impact the event is going to have on the community. There is an application that I have pending for something now that I have sent off to the Commissioner of Police and those as recently as yesterday, for sometime in April. And my thing is that I have a real difficulty with the potential for noise. But they have asked for hours that they want hours up to 5 o'clock in the morning. But that is it's not legal to begin with, but it's also not reasonable in certain environments where the noise level, I mean, I can't imagine, I'm going to take North Vegas because I know it very well. You go to the center and you sat up there, and Holton, this place is just across the street, and you're there from 5 o'clock in the afternoon until 6 o'clock the next morning. The man doesn't have chance, you know, and so. But those are some of the things. Yes, ma'am. Yes, ma'am. Okay, let's have a look at it. Because music and dancing is a particular part of the licensing apparatus, and it is actually mentioned separately from consumption. And whereas I agree with what you're saying, the practice that we have adopted here on Provo, going back many years. Remember, I took over this position. Mr. Clare had retired and gone home, and then Mr. Bean came, and he was presiding justice for a short while, and then he really went home, and he passed away. Sorry, God rest his soul. And then Mr. Clare came back for a short while, and then he decided he didn't want any more to do with it, and they shopped around for several weeks to find somebody to take it on, and they couldn't find anyone to take it on among the JPs. I'm not sure how deep and wide they searched, but then I was asked to do it, and even when I resigned, they write me back and say they're not accepting my resignation. So, but because the amount of work that is involved in doing it, especially on Pure and Provo, I'm not sure about the other islands, it can keep you very busy quite a bit of your time. And it is not a paid position. So people are not prepared to do anything for free. So that is, so it yeah. It certainly is a problem, especially in instances where it is the decision of the presiding justice alone to issue these things, and you are the person standing in the way. It becomes difficult. But I just want to take you briefly through some of the the hours that are permissible. So for a bar, a wine bar, sorry, a bar license, a wine and beer license, the hours are Monday to Saturday, 10 a.m. to midnight, provided that no permitted hours on Good Friday, and on Christmas Day, the hours shall not be permitted. No hours are permitted until 6 p.m. to midnight. Except when Christmas Day falls on a Sunday, then there are no permitted hours at all. In respect of a hotel license, whether or not it's Christmas or Good Friday, and you look at the hours that are required for restaurants. Off license. So if you go to the IGA, for example, they are, or any gas station, they are only allowed to sell you alcohol between the hours of 7 a.m. and 10 p.m. Not on Good Friday, not on Christmas Day. Yeah, so those, there are no hours on those days. Well, it says Monday to Saturday inclusive, 7 a.m. to 10 p.m. So none on Sundays, none on Good Friday, none on Christmas. So you have airport licenses, such hours as the authority decides to give. That is what an airport license can give you. For wholesale license, if you're going to a liquor store, you're buying a case of beer or beer or rum by the case and that kind of stuff, 8 a.m. to 5 p.m. period. And the hotel license, 10 a.m. to 5 a.m. the next day, Monday to Sunday. No exceptions for Good Friday or Christmas again. For restaurant license, Monday to Sunday, 10 a.m. to 2 a.m. the next day. Now, the difference with a restaurant license is that in a bar license is that when you go to a bar, you can sit down in a bar and have a drink. You don't have to have anything else. With a restaurant license, you're only able to buy or be served a drink with a substantial meal. So, and there are no bars in this country with a bar license, whether it's Mango Reef or any Shark Bite or any bar that is allowed to, on a Sunday, to sell you a drink without food. And under the laws in this country, except for a hotel license, except for an airport license, except for a club license, you're not allowed to buy alcohol on a Sunday, except with a meal. Yes, sir. Okay. I'm gonna come to that in a second. I had it marked just now, and I don't remember. But there are certain okay. In the event a person breaches the legislation by selling on those days, what you're allowed to do is to make an application. You can either report it to the licensing authority, and the licensing authority can make an application to a magistrate to withdraw their license, or any member of the public can make that application. Those are the only remedies that are available. Now, you have nightclub licenses, and you have casino licenses, and you have discotheque licenses. And let me just see those for a quick second. Yes, a discotheque license allows you to operate from 10 a.m. to 3 a.m. the next day, Monday to Saturday inclusive. And this will include the hours until 3 a.m. on a Sunday. Until 3 a.m. on a Sunday, okay? And for nightclubs, it's the same thing, which is different than your usual music and dancing, which says you must stop at 2 o'clock. Then, having sealed that very nicely, the Section 17 goes on to say, never mind what we say in Section 16, where we started all of these restrictions. A presiding justice, upon application made to him in the prescribed form by the holder of a liquor license, may grant a special extension order extending the hours in respect of the licensed premises for any special occasion, provided that no such extension can go into Sunday, Good Friday, or Christmas. Very well. Okay. Then the legislation also gives you powers to enter premises, okay, let me just read this part out in its entirety. Any police officer or a justice of the peace may enter any licensed premises and also any unlicensed premises in which there is reasonable cause to suspect that any liquor is being sold or kept for sale, contrary to the provisions of this ordinance, for the purposes of preventing or detecting the violation of any of the provisions of this ordinance, provided that a police officer or JP entering upon the premises shall not remain on the premises any longer than is necessary for preventing or detecting the commission of an offense. So, Pastor Henfield, one of the things that you can do is to go there and say to them, well, you know you are selling alcohol on a Sunday, or you're selling alcohol to minors, or selling when you don't have a license. I am not sure, short of arresting somebody or charging somebody or revoking their license, how you prevent them from selling, or unless you're going to take away their supplies. But it says that you can enter the property for the purposes of preventing any breaches of the ordinance. Yes. And the maximum penalty is a fine of up to $1,000 or imprisonment for up to 6 months. The imprisonment part is certainly much worse than the fine. Yeah, you can very well go there and do that. You can very well, I would imagine, if persons are selling alcohol to a minor, yes, you can go on the property and take the minor away from the property. Call the child safeguarding unit or the police. What is the real import of that? I don't know how you prevent someone, short of taking away their stock, from selling alcohol. Mr. Forbes? Any views?
I do not think that typically somebody would want.
And when you warn them and say that you're going to take it further, you should actually do that. Because one of the problems we have across the board in this country is a question of enforcement. And you always have where you have the authority to do certain things, we just don't do it. And it's faster and faster and grows big and big, and you end up with the mess that we sometimes recognize we have. Yes, Reverend Pastor, sorry. Well, there is no badge. There is no badge. However, there should be something, and I agree. Initially, I made a note on this thingy about identification cards that persons should have. But I would say this to, and you take it with however many grains of salt you wish. It is published in the Gazette, and everybody have legal notice of everything that is published in the Gazette, and you're deemed to know it, whether and to know that person's identity as well. But obviously, that's we know what that means. Yes, ma'am.
Oh, you almost have to pay to get the gas. But you don't see that anymore.
No.
For JPs to get it. And your number on it, so that's. Anything more good than that?
I don't see any harm in it at all. And like I said, it is one of the takeaways that I will actually go back to the Chief Justice with when we have our post seminar wrap up with her conversation with her, and it comes out of that need for persons to be able to identify themselves to the public when doing certain enforcement activities. Yes, sir. It is up to the magistrate to say. However, if a person, it is up to if the magistrate says that I am going to revoke your license, and you may apply again in 6 months, or you may apply again in a year, something of that sort. Those would be the situations.
But is the authority have
Well, one of the things that we are required to do is to listen to the advice or recommendations of the police. The police are at all the meetings, and they will say at the meeting that we have nothing again recorded in reference to Mr. XYZ, and so therefore prove that way. If there is something, they will say what that something is. The other thing you should also be aware of is that there are certain persons who you can't give a license to. You can't give a license to a person under 21. And you can't give a person who is a member of Her Majesty or His Majesty's Armed Forces, or the police force, or who is a member of the public service of the islands. So, for example, if the District Commissioner for Salt Key were to come and apply for a liquor license in Provo, I would have to say no, because the District Commissioner of Salt Key is a public officer, and it doesn't say that they can get a release from the deputy governor saying that they can do it. It says that this person can't have it. It doesn't give an exception. And we had that case with some time ago where a license was indeed issued to someone with a tiki bar, and everyone knows what I'm talking about, who was a serving member of Her Majesty's police force in the islands, and the ones that came out, and we had to withdraw the license. But thankfully, the persons who were at the meeting were aware of this person and who they are. Again, you don't always know. Unless I know the person, I may not know that they are a civil servant. But if you do that, and then it turns out that that person is a civil servant, then you have the obligation to revoke.
Mr. Gardner.
That would be section 28. Yes, sir.
You hear me?
Yes, sir. Go ahead, please, sir.
Yeah. Can you shed some light on section 18, special hour certificate, liquor for sale?
Oh, 1 second, let me just find it. Now you're talking about a special hours certificate. Okay. This is also.
You see, my concern is that what it says 18.2, which says a special hour certificate shall be in the prescribed form and shall extend the permitted hours for the licensing premises concerned until such time and on such days of the week. And you see, as the Christian nation, you know, Sundays and, you know, this will get me sometimes.
Yes. I take what you say. I will make a note. I'll make a note of it and raise it with the Chief Justice.
Okay.
But I would bring your attention to the proviso, and I think the proviso kind of cushions it, but doesn't really prevent the blow. And it says that, provided that no such certificate shall be granted unless the authority is satisfied that the licensee intends to provide a substantial meal for customers during the period of the extension. And so, whereas I can extend your hours, you must satisfy me that you have food to feed people. And if you don't have food to feed people, then I can't give you that extension.
Yeah. But my concern is really on a Sunday, you know?
Yeah, I take the point. I absolutely take the point.
Okay.
Very well. Thank you all for coming. My time.
There are just two more questions in the chat that we'll ask you to address very briefly. The first is there a role for the Director of Education in granting liquor licenses in the catchment areas of the schools?
I would not be against consulting wide if consultation is going to, or wider if consultation is going to breed result. The director of education can be involved, but the director of education, as far as I'm concerned, in these circumstances, may not bring anything more than what the planning department brings. Because the planning department says, well, this is in a school zone. This is you must be met to give this in a school zone. It's the same thing that the director of education is going to say. This is in a school zone. You must be met to do so. The director of education may also say, well, this person is even though they may be 18 and they can legally consume alcohol, they may say, well, do you really want to be selling alcohol and stuff to a child who's still in high school? And some 18-year-olds are still in high school. But it's not illegal for them to drink alcohol. Because it says once you're 18, whether you're in high school or not. And I know children in high school until they're 20, especially if they come to the islands late. But if you're 18, you can drink alcohol.
And the question.
Just one
Please go ahead.
One question. On the section 18, I noticed Presiding Justice Gardner, that you stopped at the proviso on the section 18, which stops at food, but it goes on to say, or musical or other entertainment will be provided at the same time. So we've received advice. I know as former presiding justice of the licensing authority of Grand Turk, we had received advice from the Attorney General's chambers, which alludes to the fact that it is either or.
I take the point, and I agree with you, and I confess that I had actually not, that I basically overlooked it, and I also note that it's a relatively recent provision in that it was only added 3 years, not 3 years, 20 years ago, in 2004, but it seems, because what this provision actually does is that all of the limitations that has been set up, it takes away. It sets up a regime for taking it away, which means that, which to my mind would suggest that any person can apply for a special hours certificate, and as long as they're providing you food or music or other entertainment, that on any day of the week, anywhere, that the authority has the powers to grant, and that seems a bit odd.
I think that might, sorry, with great respect, I think that it only applies to license holders.
Yes, license holders. You must hold a hotel license or a bar license or a restaurant
Any one
license
of
or a
those
gas.
five, yes.
Yes.
Now, the only question it'll be interesting from your experience, especially Provo being a more dynamic area than Grand Turk. The question is that how do you define musical entertainment? Is it just simply having a jukebox with some music popping?
I think each authority will have to decide that for themselves until a magistrate tells you what it is, or until the legislature comes back and sets out a particular definition. But certainly, to my mind, musical entertainment is more than having some background music playing while you eat. In a restaurant, if you have music where persons are, I don't know, I would imagine. Well, I don't know. I don't know. I don't know what my view is.
Okay, well, my only suggestion is that you might want to take that up with the Chief Justice as well to provide either legal based guidance on it, or to have the amendment, because it even goes further. It says or entertainment, so we could probably have
Arts.
just a few dances, for example, providing entertainment. Is it sufficient? I think it's an area of abuse, I think, and I think it's worthy of a further clarification,
Yep.
and probably some guidance to all the licensing authorities.
Does any licensing authority use those special hours certificate?
Oh,
Cases?
yes, absolutely. I mean, it would be impossible, for example, for Margaritaville at the cruise port to continue to service guests on cruise ships on a Sunday. If it were not for such a provision.
I take your point completely. Yes. So, but what this is saying to me is that those people across the way over here, Sweet Teas, they have a restaurant license. You can literally go there and they can be open 24 hours a day, every day of the week, selling alcohol. If someone is crazy enough to give them a license. But I take the point, Mr. Quelch.
Thank you very much, Mr. Gardner. There's one final question, and it's, are there any proposed penalties for JPs who do not attend liquor licensing session?
Oh, there are no penalties. However, what we do is that we provide the registrar of the magistrates court with the agenda and with the attendees, and if it is that the registrar feels that persons aren't participating, they may wish to take other actions, and that can be having them removed, because it's a part of your civic duty to attend these meetings. If you're not doing it, then same way Mr. Forbes and I and the district commissioners aren't paid for this extra work that we do. There's no reason why that some of us should be burdened with it and others aren't.
Yep. Well said.
I do not know. I know that I've made a note, and I'll raise it. On that note, thank you for coming, and hopefully at the next training session, you will have somebody more entertaining to listen to. Thank you very much.
So thank you very much, Mr. Gardner, for that informative presentation. And I'm sure everyone will agree it was very entertaining. So we'd like to thank all Justice of the Peace for attending today's seminar. Those of you joining us virtually, we thank you for your attendance as well. For the persons in person here today, we have certificates from our last seminar. So I'd ask you to please stay back. For persons online, please remember to place your name in the chat so that we can record your attendance. And for persons in person, please ensure that you've signed one of our attendance register. Thank you very much for your attention this afternoon. And thank you again, Mr. Gardner. So have a good afternoon, everyone.
Thank you.
And one final point before we dismiss. These certificates for today's seminar will not be issued immediately. What we've decided to do is at the end of the second seminar for the year, we'd issue one certificate for both seminars. So thank you very much.
I hear you.
Yeah, add, you could add